Hello, everyone. Welcome to IPWatchdog Unleashed, where each week we journey into the world of intellectual property to discuss the laws, news, policy, and politics of innovation, technology, and creativity. With analysis and commentary from industry thought leaders and newsmakers from around the world, IP Watchdog Unleashed is hosted by world-renowned patent attorney and the founder of IPWatchdog.com, Gene Quinn, who has twice been named one of the most influential people in the intellectual property community and recognized numerous times as one of the top IP strategists in the world. Take it away, Gene.
Thanks, Renee, and welcome everyone to this week's edition of IP Watchdog Unleashed. This week, we have Robert Plotkin joining us. Robert is a patent attorney. He's been a patent attorney for 25 plus years. He is a software expert. He is an AI aficionado. He traces his roots all the way back to MIT and his computer science degree. I met Robert a number of years ago when he wrote a book titled The Genie in the Machine, which I thought was just so insightful. I was reading page after page saying, amen, amen, amen. I immediately reached out to try and talk to him, and I have since got an autographed copy. I'm a little bit of a fanboy. That was a great book, and he's written another book we'll talk to him about as well. But Robert, thanks for joining us here today.
Thanks so much, Gene, for having me. It's been great knowing and working with you over these years.
Yeah, it's been great. You've done some webinars with us. You've been at some of our programs, and I'd love to include you whenever possible because I do think you have, one, a great way of explaining very difficult concepts, and two, it's very clear you know what you're talking about. And I think in this space, and that'll be something I want to get into with you, sometimes I think some of the problems that have occurred in the software space at large have been because people who really didn't know what they were doing thought, oh, software, it's easy. I can handle that. It's a method. And that led to a lot of bad cases, making bad law. But before I get ahead of myself, let's talk to the audience about how this journey started for you. Now, I mentioned that you are an MIT grad, but how did you get into this? Were you a computer geek in high school? What was your entree into this area?
I was a computer geek in high school. Even before high school, I often tell the story how we got a computer at my public school in Brooklyn when I was in fifth grade. It was a TRS-80, and I got hooked on that, programming in BASIC, and then, Atari computer. This is all in the early 80s, and I did it as a passionate hobby as a kid without many resources really to draw on. I didn't know other people who were doing it. There wasn't much at my school or anything, so I pursued it very much on my own, but just always loved programming. And in fact, one of the things I did in high school was write some software that now we would say was machine learning. It was based on a project in the 60s that someone named I want to say James Mitchie did to teach a physical system how to play tic-tac-toe. And without getting into all the details, he took matchboxes with different boards on them and put beads in them to rank the value of the move associated with that game. And then he would play tic-tac-toe, and if a certain move won, he would add a bead to it. That's essentially like reinforcement learning in machine learning, but he didn't have a computer to do it back then. So he did it in a physical system. I then wrote some software to do that at the time, and it would run and play against itself and engage in machine learning. And one of the reasons I like that example is, you said that a lot of the problems we've had come from people not understanding the technology. That's a great example of how the distinction between software, which may seem intangible, and hardware, which people see as tangible, and then often draw a legal distinction between the two, really breaks down. Because in that case, you could implement that learning system in a set of matchboxes with physical beads or in a piece of software. And yet it's all the same process. It's all the same system. And there's not really a good basis for drawing a legal distinction, particularly patent eligibility, right, between one implementation and the other. So Yeah, I've been doing it for a long time. I did go to MIT, and then I'll thank MIT for teaching the integration between hardware and software. I mean, I was always interested in software, but I'm glad that part of the requirement in that, even in the computer science degree, was to take several really hardware heavy courses, including, one I remember we built a computer up from scratch, including the microcode. And so that really helped me to see how the hardware and the software are all part of one computer and interact with each other, and how the lines between them can shift and be blurry, which, as you indicated, when people, judges, not to blame them, or patent examiners, don't understand how the computer actually works on a hardware and software level, they can end up drawing distinctions between hardware and software that have legal implications that don't really have a basis in how the technology actually works. And I'll say that then when I started practicing law around 1996, it was an exciting time, because for me as a computer scientist, software was just, you remember 94 was the big year in the federal circuit where there was a big shift. Not that software patents didn't exist before then, but there was a big shift with Allopat and Arrhythmia and a bunch of other cases really opening the gates. And, law firms and practitioners at the time were very much like with AI now, getting demand from clients to patent their software. There was a need for it. The door was open, and yet it was unclear. How do you do it? How do you write a software patent? What's going to fly at the patent office? What's going to stand up in litigation? So that's when I started. I got a lot of great training and a lot of experimentation, again, because we didn't know how it was all going to pan out. And then I'll just fast forward and say, in one form or another, I've been in private practice, mainly as a prosecutor, handling software and AI patents ever since.
So there's an awful lot there. And again, like I was when I've read your books saying amen, amen. I think there's so much truth to what you say. Before we dive in too far into that, though, I do want to learn a little bit more about the genie in the machine. I was thinking it was we were preparing for this conversation. I'm not sure I've ever asked you about these questions about why did you actually write the book? I mean, I think I know why you wrote the book, but why did you decide to put it into not just like an article or two articles, but really a book form, and explain this the way that you did? Because anybody that can read it can see that the roadmap is there, and that was one of the things that also interests me as to why did some attorneys struggle to figure this out, because you laid it all out.
Yeah, the motivation originally wasn't to write a book in the form it eventually took. The form it eventually took was about AI and how people were using AI at the time, which was around 2005 to 2009, to boost and augment and automate the inventive process, and then explore what are the implications of that for patent law. But my original motivation really was to explain the things we were just talking about. Why is it that software, when it's implemented on a computer, really does create a new or modified physical machine? And why should those things be patentable? And what are the misunderstandings people have had about all of that? And in fact, I wanted to make a broader argument that computers, if you look at them in the long arc of history, going back from when people first started to invent, there's been always a motivation to create tools that make it easier to invent. Mm-hmm. Inventors don't just create a new hammer to build a machine. They create a new hammer to help them invent something else more easily. And my main argument originally was, if you look at computers in that line, they are a type of machine that made it possible. I mean, going back to Turing, even or earlier, there was a dream of making it possible to build a machine that you could modify by giving it instructions in a language and thereby not have to engage in that tedium of designing new physical parts. And Turing and others at the time first started calling it a universal machine. We now often call it a general purpose programmable computer. But my point was, even before AI, we should really be seeing computers as tools that made a break from having to invent by engaging in physical design of new parts to inventing by writing instructions that you can give to a machine, the computer, to then modify itself to become physically capable of performing the functions you described. And the reason I then made the shift to making the book more about AI was I found the first argument was very hard for a lot of people to grasp. And it wasn't going to be easy to make a book out of it unless it was a purely academic book. And I wanted to reach a broader audience. So when I started to find that people were using AI to do things like create designs for circuits or airplane wings or antennas, I thought, well, that's something that people can get easily. And then I could make the focus of the book be that, and then use the software as a invention automation machine, more of a secondary point, even though it's what I was more interested in. And then, of course, fast forward to now, it's much easier for people to get why it's relevant and significant that people can use AI to assist in the inventive process. It was a harder thing to convey then when the AI technology wasn't as powerful and when it wasn't in as wide use for inventing.
Yeah, AI has been around for a long time. When people seem to get really excited and think it's new, it's a different generation of AI that they're talking about. But the technology has been around for a long time. And one of the key things that I think certainly judges miss, and maybe some examiners, although they probably get it a bit more, and a lot of them are just doing what they are told to do by the office and or what they think is being required by the federal circuit. But there's way too many decision makers throughout the patent world that just ignore the reality that the innovation is not software. That is a design choice. This could be done in hardware or it could be done in software. The fact that you choose to do it with software is a choice. You're manifesting the innovation, which is something else than just the code, in a software product or solution. And that just, I don't understand why that is so hard to get. I mean, Google years ago filed a patent on doing something in software. I forget what the title of the patent was, and they showed the circuits that you could build to actually do it. That was when, I think that was after Alice, when all this stuff, well, what are we going to do? How are we going to do this? How are we going to convey this? And yet it still doesn't seem to get through. Then the other problem, I think, with the confusion came about in about 1998 when State Street gets decided. Because I think we had hit a steady status quo. People figured it out, Allopat, arrhythmia, great cases, good decisions. Then State Street opened the floodgates for business methods. And then an awful lot of stuff that could have and should have been protected as a software patent, quote unquote, wound up getting patented like they were recipes. And every patent attorney can write a recipe. Everybody can write a method claim. And then these software patents became wish lists with no technology. And that just led to all kinds of problems, I think. And I don't know that we've ever recovered from that.
I agree. I mean, I absolutely agree with you. And one of the recurring problems, and that State Street is a good example, is that, patent eligibility is always been used to try to address several different issues when it probably isn't really meant for that. One of them that you mentioned as the wish list, you could say is a lack of enablement. And if that's the problem, that people
Mm.
are submitting applications that really aren't enabled or aren't enabled for the full scope of the claims, let's tackle that by enforcing the enablement requirement in a real way and not by using an eligibility as a sledgehammer. I think that's part of the problem is either when people don't understand the technology or are trying to achieve other goals, they use eligibility as a sledgehammer. And when you use it to really address what should be handled under enablement, or as Director Squires has been hammering home, to address novelty or non obviousness, you have problems because it's not designed for that purpose. And then you're going to go too far in the other direction and end up excluding from patentability inventions that really should be patentable as long as they satisfy the, enablement, written description, novelty, and non-obviousness.
I think that that is, in a nutshell, what's going on. I also think that there was maybe it was fortuitous, maybe it was planned, but by making all of this eligibility issue, once you get to litigation, it can be handled on a motion to dismiss rather than if it's a enablement adequacy of description issue, it can't be on a motion to dismiss because you have to construe the claims, which means look at the prosecution history, actually read the patent, which I'm not sure that they really do. And you've got to look at the prior art and admissions that were made and all kinds of things. And then you even look at dictionaries and what other people of skill in the art would understand this to be. None of which, maybe not none, that's too much. Most of which does not get considered at all on a motion to dismiss. And the thing that just irritates the heck out of me is I don't know how you can possibly say a claim is abstract if you haven't construed it. Because you're looking at the words. The words, I mean, look, if pick a language you don't speak, whether it's a computer language or whether it's a real physical spoken language. Like I don't speak French. Okay. If I look at French, it's going to look like gobbledygook to me. Right. But it's not. People who understand the language understand what is being said. And how you can look at the claim and say, oh, this just doesn't mean anything, this is abstract, without reading the specification and asking what would the person who this was written for them to understand get out of this document and these set of claims. And it's frustrating. It's frustrating. I mean, I know you share the same frustration, but what do you tell clients and what do clients ask you? Are they just like befuddled by all this?
Yeah, they are befuddled by it. This is probably going down a whole other path, but the point you raised just makes me think of the distinction that's made in the US between how claims are construed in prosecution versus in litigation, right? That we have
Mm-hmm.
this broadest reasonable interpretation standard used in prosecution. I know people have different thoughts about it. I think for me and my clients, we prefer to have, I would be willing to take on whatever downsides there might be to having the claims construed in prosecution the same way they are in litigation, in light of the specification. And I know the prosecutors say I'd rather not have that happen, but to me it would eliminate a lot of problems with claims being construed, as you said, just on their face broadly, which is not what they really mean, and it's not what they're going to mean in litigation. And that disconnect is something that's hard to convey to clients,
Mm-hmm.
because they have a certain intent with what they're conveying to me. I do my best to put it into the patent application as a whole, which is the specification and the claims. But the way we, of course, have to then handle it in practice is if we want the claims to have a certain meaning in prosecution to get allowed, then we have to put that expressly into the claims. And what does
Mm-hmm.
that mean? It means that sometimes you're going to have to file more continuations or have a bigger family to get a fuller scope of protection, because you had to narrow the claims in a certain way in prosecution.
that could open up a whole nother avenue, right? Because continuations are not in vogue at the moment, at least by some judges. They're finding prosecution laches in ways that I think just defy logic and certainly defy the statute.
Right.
Um, but I don't want to go down that path because there's so many AI questions and not to say that I don't want to talk about continuations, because I do think you raise an interesting thing that I did specifically want to get into, is this idea of the patent gold rush. I think a lot of companies are just chasing, press releases. We're filing this patent, we're filing this AI patent, we got these AI patents, and so on and so forth. And then I noticed like the real, the foundation providers, you might say, of the new generative AI, they file patents, but they're not like going for patent count. They're going for value, right? And they're going for a handful, almost in the same way that a pharmaceutical company would, right? They want some core stuff, well described, protects what they need protected. And I see these two different strategies, and I think I know which one I would like and to follow if I were a general counsel or chief IP counsel. Which one do you think is right? And I know that that's going to be tough because different companies at different levels for different reasons. But what do you tell somebody about what they should do when they're building their AI portfolio?
Yeah, I do tend to prefer to focus on a value, which means know what I think Peter Lynch, right? Know what you own, know why you own it. Know what patent you're pursuing and know why. What is your goal? There's many different goals. You can't optimize for all of them unless you have an unlimited budget, which no company has. And so, what are the most common goals for pursuing a patent? First one, traditional one, would be protect your product that you're selling so that if some other company starts selling a competing product, you can block them or at least compel a license from them. That's for an operating company. You want to use the patent to block competition, or at least get licensing royalty from it. That's the first one. Now, the other one for startups is often they're using it for fundraising, which then you want to keep in mind who is your acquirer going to be in the future, most likely, which might mean you're pursuing a patent that goes beyond what you're going to be selling to what your acquirer is going to be selling. Then there's the goal of monetization, where you're going to be litigating in the future or just doing a pure licensing campaign. And there's others. Those are three big goals. And what I always tell clients, which seems counterintuitive to them, is which patents we choose to file, even in the first place, and then how we write and how we prosecute them is all going to be influenced by which of those goals you have and how much resources you have. And here's one example of a pitfall you can fall into if you don't think that through, and you go with the volume strategy you're talking about, which is particularly these days with AI, it's so easy to write huge omnibus specifications. The risk you fall into there, particularly I see clients coming to me who've already self-filed their own provisionals, and they've done that apparently, using assistance from AI, let's say. Well, what if that application describes 50 inventions and you only end up pursuing patent protection for one of them? Now you've potentially dedicated to the public everything else because it's all published. So I always tell people you need to think about, before filing anything, are you ready to commit to really pursuing patented claims on everything or a wide range of what's in that initial set of specifications you file? Because if you're not, you could end up in a situation where you've published this huge specification and only patented, a tenth of what's in it and everything else. And what if you had wanted to keep some of that as a trade secret? You can't anymore. So that's a big risk of thinking we're just going to preserve all options now, and try to cover everything and then focus on value later. There are limits to how much you can do that. So it's just another reason I'm agreeing with you. Think about what it is what goal you're trying to pursue, and pursue that in a more focused way.
Just to explain this for some people who maybe are, not the generation plus in this industry doing this that you and I have had, they might hear, well, I thought provisional applications are not published. And that is true. Provisionals are not published. But if you're going to rely on that provisional to support priority for a non-provisional, then that provisional becomes a part of the file record for the non-provisional that is published. And by the time that happens, now things are out there. It's too late often to go back and file based on what you've been doing in the interim, in the meantime rather. And that's how you take an omnibus filing that has all kinds of great stuff that should have been trade secreted, and you turn it into completely worthless, valueless, and you do dedicate it to the public. And so let me ask you this. I mean, because oftentimes throughout history and with certain inventions, this is probably still true. You want to file first before you do anything. You want to get to the patent office, particularly in areas where there's a lot of people that are working on things. But in this space, I wonder whether that's the right strategy, right? Because, you got to have some idea about what's going on. If you go too early and it's not really enabled, maybe it couldn't be enabled because you really don't know yet. You have more questions than answers. You're figuring out as you go along. When is the right time for them to move forward? And does it depend upon whether it is a foundational platform level innovation versus something that is an incremental improvement to something that already exists? And there's nothing wrong with incremental improvements. Patent law is full of them. The history is full of them. Edison incrementally improved the light bulb. It just was a gigantic incremental improvement. So that's where we live. But in this space, platforms are going to stand the test of time better than those incremental improvements. And I think maybe you might want to think about them differently.
Yeah. So I agree. There are two incentives. There is a strong incentive to file early because innovation's happening so rapidly right now. And it's not only happening rapidly, I've been seeing more patent applications, particularly from India and China, get published really quickly, and therefore they're available as prior art. They're not always taking 18 months to get published. So what I tell clients is, let's try to file as quickly as we can for what we can enable now. And then if it's a provisional, if you've got something that's more enabling for a different scope in a few months, let's do another provisional. But we have to focus on enablement. And I think that with AI in particular, with AI related technologies, it's easy to convince yourself that you have a description of something that is enabling in a broad scope before you've really proven it. And so you just have to pay careful attention to that. It's easy to say, here is a process I've got that uses a model and it runs over a loop a million times, and therefore it could produce any output that solves this problem. Is that true or not? That's an empirical question, really. And so you can try to convince yourself of it in the abstract, but in some cases, either you have to do the testing and see, and maybe you've enabled it for a certain range of problems only, and that's what you should focus on claiming soon. And if you don't do that, maybe this is going to get tested in litigation later, and I'd rather try to avoid leaving it until then. I'd rather file something now and write a claim that's limited to the scope of what we're confident we can enable now. And then that gets back to, why are you trying to patent this and what is your goal, and stay focused on that. So I encourage clients to do the testing. I mean, I did a lot of speech recognition related patents going back 25 years. And, then you had models that on their surface looked like they would do well at recognizing speech, but until you actually tested them against a wide variety of voices, you mentioned people speaking in different languages with different accents, you didn't necessarily know. And so I just encourage anyone developing AI now to actually test what you're doing. And then when you work with a patent attorney like me, that will help me advise you on what we can claim. The fact that we can describe it doesn't necessarily mean we've enabled the full scope of it.
That's right. And it almost feels like the AI practice now is a lot like the life sciences area because you have to be very careful in these highly unpredictable areas. Because if you wind up claiming things and yeah, what you had in your head, it worked for that, and the words you use would cover that. But then it doesn't cover the stuff that comes next. But the words could technically look like it should or that you intended it to. Now you're in this world of hurt where life sciences people understand that very well because they highly unpredictable stuff. You got to claim what you specifically know and what you know works. And that hasn't always been done as much as it probably should be outside that area because it can be more concretely known and you can prophesize and come up with, hypothetical working examples and stuff. But it's very, very dangerous to do that in this particular space. And when you say the word any, maybe as a general rule, anytime you say the word any, you're making a mistake. And the same way with, like there's so many of these pitfalls in the AI space or software space, even just generally, general purpose machine, specific purpose machine. These things have no meaning. I mean, it's ridiculous what's going to happen when you have somebody who thinks because they have used AI or used software that now they're an expert in AI or they're an expert in software, making these decisions, and they make these distinctions without a difference. And I think you just got to be very careful what it is that you're doing. And if it's valuable, make sure it's protected. And I do think, so this going back to where we went down this path with continuations, I am not a fan of the patent count. I think it's got to be about value. It's got to be about protecting things that matter. Having said that, I do think you need to have a robust continuation strategy because like in the life sciences area, you want to protect something that you know works today, and then you hope later on down the road, as you learn more and more and more, you can protect more stuff that you described in the application. But if you start trying to do broad and small, something for everybody in an AI application, I think you're just running the risk of losing everything and getting nothing.
Yeah, I agree. This distinction between general purpose and special purpose doesn't quite make sense. It's a useful heuristic, but maybe not much more than that. And the same thing between what we used to call predictable and unpredictable arts, right? I don't know that we can say whether AI is predictable or unpredictable. We have to really look at it on a case by case basis, and it changes over time. And so if you get too locked in to thinking biological inventions are unpredictable and software related are predictable, I mean, that's clearly no longer true across the board now. With machine learning models that are stochastic or probabilistic in nature, they can be unpredictable to various degrees in different circumstances. And a lot of the innovations that are happening in AI now are trying to create software systems that manage that unpredictability and make the end result more predictable. I often analogize it to, network protocols that operate on noisy networks, right? Where the underlying medium is unpredictable, and then you create a communications protocol that results in your ability to engage in communications to 99.9999% accuracy or predictability. That's a lot of what people are doing now to try to build on, let's say, large language models and their unpredictability, but encase them within bigger systems that can produce highly predictable outputs despite the unpredictability. So it's just another way of saying trying to apply a term like predictable or unpredictable to a big field like this is only going to lead to confusion. But it does mean that from the point of view of a patent practitioner and of clients working with a patent practitioner, we should really need to focus on being confident that we can enable what we're trying to patent in each case. Forget about what's predictable as a whole in the field. Doesn't really matter for the individual applicant in the individual in patent or in the patent portfolio.
I think that's very insightful because it's not like an entire field is or is not predictable the way that it was probably when we started at the very beginning, or at least the way we were taught it was back in the day. It's all about the facts on the ground. In some areas, things that technology areas that have been long believed to be predictable are no longer really predictable because of sometimes science moves. You learn more things, and sometimes it's just the pushing the engineering forward and having it abut with other areas, like in the or organic memory area, for example. I mean, like computer memory that can be organic. I mean, well, where does that fit? Is that computer sciences where it's a little bit more predictable, or life sciences where it's not predictable? No, it is what it is. And in that particular area, you have to take it as it comes. And I think that that's part of the one exciting thing. But two, it defies pigeonholes, which those who are not technologists like to find, well, what's the pigeonhole that this is most like, and how do I fit it into that pigeonhole? And it's very, very hard to do. Quantum computing, for example. I mean, like, I don't know. I mean, you know more about that, way more about that than I do, and you've talked about that on our stage, and I used that as a podcast episode, which was actually one of the most popular podcast episodes we've ever published. But it's exciting, but it's who knows? I mean, is it predictable? Is it not predictable? Well, we'll find out, I suppose. Like in 20 years, or maybe not 20 years, probably 10 or 15 years, as these patents have hit about the 10, 12 years of maturity, and now they start getting litigated. Now we're going to find out a whole lot more about that technology than we know today, and certainly when they were filed 5 to 10 years ago. It's exciting, but going back to the general purpose thing, the reason I say that, I think it is a symptom of those who don't really understand trying to pick labels. And so for you and I, we could talk about general purpose machine versus a specific purpose machine, and we understand what that means, and we understand where it makes sense, and we understand where it doesn't make sense. And I think, unfortunately, with things like that people, I can get that. It's a general purpose machine. Oh, it's a specific. No. Stop using just the labels. And the reason why that particular label just drives me crazy is, remember back in the day, I'm sure you do. Back, there was IBM and there was Apple. And if you had IBM, you couldn't use anything that related to Apple. And if you had Apple, you couldn't use anything related to IBM. And these things didn't talk to one another. And even like with instant messenger, something as simple as that, you had AOL, you couldn't talk to people who had Yahoo or any of the others that, this interoperability it didn't exist. And I think it was almost in some ways intentional for at least as long as it lasted. But one of the things that made some of these very early software innovations valuable was they enabled cross-platform operability. And that there, for a while at least, made it seem like the judges would say, oh, you mean this could run on any computer device? Mm-hmm. So it's just running on a general machine. Well, if it can run on any device, then it really isn't that unique. And it's like, no, my God, that's the whole point of what makes it unique, is it can run on any device, whether it's in your pocket or you're staring at it on a monitor, or it's a tablet or it's a mainframe, it can run everywhere. And I wonder whether that type of problem is happening again with AI. And maybe it's not, but it is a slippery slope when you have people who really don't understand the technology feel like they do.
I think you're hitting on something very important, which is, I tried to talk earlier about the long history of technology that we've seen many times some new platform be created, which enables some sort of general platform, which enables innovation to happen on top of it. I mean, I've often heard people talk about the Remington uh, uh, approach to manufacturing, which was the first right gun with interchangeable parts, and that was, you could say, a general purpose platform where you could then swap in and out different parts. I've often used the analogy of a drill, right, which is like a platform for attaching different bits that perform different functions. You could put a screwdriver bit on it, you could put a sander bit on it, you can put all kinds of bits on it. The drill is the platform, that's sort of the general purpose machine, and the bits that you attach then perform specific functions. Now, the fact that that's a platform, does that mean there can't be innovation in creation of the new bits? Of course not. I mean, there's probably thousands of patents on new types of bits. But somehow, every time there's a new platform, whether it was what we're calling the general purpose computer, or large language models and the software that runs them is sort of a platform for innovating using natural language. Every time it happens, we encounter the problem you just mentioned, which people say, oh, that is now somehow abstract and it enables everything. And therefore, anything you build using it can't be innovative or technological or innovative enough to be patented. It's not a new thing, but what's frustrating to me is both I'm old enough to have lived through it enough times, and I read history and I've seen it enough times, and just we keep making the same mistake every time to conclude that the things you build on or using the platform can't be innovative just because the platform is powerful. Some of the things you said make me think that there's also something going on, and I'm trying to say it in a blaming way, but that various people in the system, maybe it's a natural tendency to want to find a simple general way to approach all of these individual cases. And patent eligibility is an easy one to say, let's establish this general rule that if you don't create new hardware, not patentable. If it's on a general purpose computer, not patent eligible. You could see it as a way of avoiding having to engage in the hard, not pleasant work of evaluating each invention on its own merits on a case by case basis in patent law for novelty, non-obviousness, and written description and enablement. It's way easier to just say, nope, doesn't fit into the right category, and then just end it there.
Yeah,
So
and
there's probably a lot of that going on. Let's just dispense, whether it's a judge or a patent examiner, I just want to dispense with this thing really quickly. And here's a simple sledgehammer for me to use to do it.
I think there is a lot of that going on. And the only thing I would say is that in this space, I think this is the first time this has ever been done with 101, where this is not patent eligible. And in the past, the problem that you were just describing has come up all throughout history under 103. And it happens like where it becomes ubiquitous. This was so important that everybody is using it. And then once everybody starts to use it, it becomes, oh, that's obvious. Well, certainly in hindsight, once everybody's using something, it is obvious. It is not obvious before for an awful lot of inventions. The one that it just irritates me, again, like fingers on the chalkboard, is the Wright brothers. Oh, everybody knew how to, no, nobody knew how to fly. And if you go back and you look in history, the key insight that the Wright brothers had is that everybody's trying to fly like a fish swims, but a fish doesn't fly. Maybe we should be looking at birds because birds actually fly. And they noticed the birds, they warp their wings as they're moving. And that was the beginning of man flying, was that realization. And then there was an awful lot of trial and error that went into it after that, of course, and real innovation. But that insight was not obvious to anybody other than the Wright brothers. And to say otherwise is to just rewrite history. And I think it happens a lot with those kinds of paradigm shifting, fundamentally important, foundational innovations that become ubiquitous. And now what we have is that same exact problem, but it's rearing its head as eligibility. We're not even going to ask whether this is new. We're not even going to ask whether it was obvious. We're just going to say no patent for you because. Mm-hmm. And that's a different world.
Right. No, it's a great point. And you probably know more about the history of the 1952 Act, but that was a big motivation, right, for writing Section 103 the way that it was at the time. And so now maybe since then, people have shifted and are using 101 for that same, I'll call it work avoidance or intellectual effort avoidance purpose. And so that's why I think you'd agree with me. We were ripe for a time to rewrite or revisit. It's calling for a legislative solution, really. I usually don't think that, but I have come to think that for 101.
It absolutely is. I think, and I also think I think once we settle 101, then we're going to have all kinds of problems under 103 and 112. And the 103 issues, people I don't think realize just how awful KSR is, because so much of what is getting killed gets killed before 103, it gets killed at 101 at the door. But if we solve 101 and things are eligible, then I think we're going to have this ubiquity problem. Oh, I use ChatGPT. Oh, I've been doing that for a decade. Yeah, well, the patent was filed 15 years ago. And for whatever reason that disconnect happens, and sometimes lawyers don't do themselves any favors either when the judges will, ask questions like famously during the Alice case. Well, this could be coded by a second-year engineering student in a coffee shop over a weekend. That question was almost verbatim asked that way. And the answer was yes. And the answer was no, no, you can't. you can't. I mean, it showed no understanding of what engineers know in their second year anyway. I mean, you couldn't, unless you were a savant and just went in with knowledge, you didn't learn anything in engineering school that was going to let you code that in a year and a half or 2 years. And two, could you do it? Yes. Could it work? Yes. But what about all the stuff that could go wrong? Well, what if you press here? Oh, well, I didn't. What about hackers trying to get it? Oh, well, there's all kinds of, the engineering problem is very real for software. And I don't understand why more people don't realize that. They treat it like it's simple. Well, if it's simple, why do we have hackers? If it's simple, why is there data breaches? It's because it's not simple. It's not simple. And there are holes and there's openings. And that's the whole point of a lot of companies. Actually, my son just started getting a job working at a company that does this. This is one of the things that they do. They create tools to analyze vulnerabilities. And it's a big industry. Cybersecurity is why does cybersecurity exist? That this is, one, so easy, and two, there's no problems. All you write it, and you never have to worry about it. And it's just, the clues are everywhere.
They are. I mean, here's two things. I agree. People, even within the software world, I think, tend to not give themselves enough credit. I suspect it has something to do with the fact that software is created, again, by using instructions. And maybe it's just some deep held belief that rolling up your sleeves and physically building something is harder in some fundamental way. When it's different. It doesn't mean from a 103 perspective that software innovations are inherently more obvious, but I think there's something psychological and not necessarily rational about the distinction. But here's a specific example, which is, we said when I wrote the Genie in the Machine, that the AI technology wasn't as powerful as it is now. What's changed since then? It's been a set of hardware and software innovations. All of the GPUs and parallel processing hardware, there have been incredible innovations in that have made the hardware orders of magnitude more powerful. But then, in addition, there was deep learning on the software side, GPTs and transformers on the software side. Neither of those in isolation would have produced the revolution we're experiencing now in generative AI. There was the hardware and there was the software. Why would we think that the software is inherently less innovative or less worthy of protection when in the real world it's played just as an important role in making all of the technology we experience now possible?
Again, amen. I don't have an answer to that because it seems so obvious to me, but a lot of this seems obvious to me, and I think I could do so much good if I could just be given control for one day and put it all in order. But this has been a fascinating conversation. I really appreciate you having it with me. But before I let you go, let me see if we can end on maybe a positive note here. Not that we were Debbie Downer, really, but sometimes it is a little bit Debbie Downer here with what can be protected and what winds up being protected, and then also sometimes the clients make mistakes before they even come to you that cost them dearly. But what should a client be asking themselves at the front end? Particularly, I have in mind, should I be filing a patent application on this? Or is it not yet ready? Or is it really something I should just keep secret into myself and get as much out of it as I can before I move on? What question or set of questions do you want to leave those startups with here today?
Yeah, the questions relate to the legal requirements, but they also fundamentally relate to the business value, which is I ask them, what is it that you have developed technologically, whether in hardware or in software, that you had to develop because you couldn't get it off the shelf? There was some problem you were trying to tackle to address a need of your customers and your product in the marketplace, and you had to create it because you could. Look, companies are very cost conscious. If they can license something or in software, buy a library that exists, they'll do it rather than having to build. But if there was something you had to create because it didn't exist, what was it? And does the existence of that feature in your product stack give you a competitive advantage over competitors, which if they could not put that feature in their product would really give you a business advantage over them? If you can say yes to that, it's at least worth talking to a patent attorney. They still have questions about, is it going to be patentable? Is it going to be valuable long enough? Is it better to keep it as a trade secret? But that's something I think an individual inventor, startup company can get a good handle on and then know whether it's worth going to a patent attorney to have the first conversation.
Awesome. That's great, Robert. I really appreciate you being here. And as you know, because we talked about what we wanted, we didn't get to half of what we thought we might get to. So I'll have to have you come back. Hopefully you'll come back. And I hope I get a chance to see you in person soon at one of our events again. But thanks so much.
Oh, thanks for having me. Yeah, I'm looking forward to coming back to more IP Watchdog events.
Thank you for listening to IP Watchdog Unleashed. We will be back next week, and we hope you will join us again. In the meantime, please be sure to visit IPWatchdog.com to read all the latest news and information about what is happening in the intellectual property world. And also be sure to subscribe to our free daily email newsletter.